Did a video last week on how jointly owned property can screw up your plans if you have a prenuptial agreement and each spouse is supposed to keep their own assets. Well, when you start jointly titling stuff, everything by operation of law is going to go to the surviving spouse, and then it's going to go under their plan to their children, and the first spouse to pass's children get left out in the cold. Today I want to take a spin on that. Talk to a gentleman today who lives up in New Jersey. He's looking for asset protection for many of his rental properties. He has 2 rental properties in Florida, and he has like 9 in New Jersey. And he made this statement during our consultation that many of them are jointly owned with his mom. And I said, well, is there a reason for that? And he's like, no, we just figured having more than one name on the property provided some layer of asset protection, which it kind of doesn't. But more to the point, I asked him, how are those deeds set up in Florida and New Jersey? If it's just you and mom as individuals, then when mom passes first, making the assumption that statistically she will die first, when mom dies, her piece of the ownership of those properties may need to all go through probate. And since she has property ownership in Florida and New Jersey, she may be dealing with 2 probates. And more importantly, since you paid for the property and now your mom is on title with you, there is a serious concern that when mom passes, her 50% of the properties are going to, A, go through probate in 2 different jurisdictions, which is going to take a lot of time and cost a lot of money. And then more importantly, those properties are going to go by way of her estate, which may mean that one or more of your siblings is going to end up legally owning a piece of property that you paid for, that you just added mom to for some measure of convenience or security that doesn't really exist. So be careful with jointly owned property. If you do own property with a family member, make sure that you spell out an understanding with that family member of what happens if each of you were to pass away. And then make sure that, in this case, they would have wanted to have joint owners with rights of survivorship versus what we call in Florida tenants in common. And tenants in common, as each owner dies, their share will need to go through probate, whereas rights of survivorship automatically go to the surviving owner or owners. So be careful with jointly owned property. It can screw you up several different ways. Make sure that you know what you're doing, that you know what you have, and if you're confused, find a competent lawyer that will explain it to you. Have a great day.